Thank you very much. Hi, everyone. Good afternoon. It's a pleasure to be here, and thank you so much for the invitation. So I'll kind of try to feed into this discussion of remuneration rights, but with a different framing and a different entry point in particular. So I've thought about seeing this as the reasons why GRULAC in Latin America more prominently wanted to bring this discussion to WIPO, and how there's kind of a big mismatch between what's taking place at the national or regional level and what's taking place more globally. So one way to do it, my interpretation is that we need to understand that, at least in Brazil, potentially slightly different from what we're seeing in Europe, there's at least these two main things here. On the one hand, renewed attention to creative industries as strategic to the Brazilian economy, Latin America more broadly, and on the other hand, regulation of huge platforms. So not quite copyright at the focus or at the core of what we're discussing, but if we try to delve deeper into these two streams, the main point is what's there in the box in blue. It's the post-Bolsonaro context. So this is pretty much also responding to an authoritarian context in which you had severe cutting in culture industries financing, but also deregulation in the platform sector, which also led to direct consequences for democracy, just like we saw in other countries as well. So if we try to look them from that point of view, when we look at how this new government try to pitch creative industries as one core focus, you see tons of new fiscal policies, you see tons of new legislation and direct and indirect support to not only authors, but movies and all different cultural sectors, accompanied by, then that's where we get to remuneration issues, low to minimum to absolutely no remuneration at all for authors, in particular by foreign large platforms. And it's said all the time in Brazil that our Minister of Culture, who's also an artist, she pretty much gains nothing, and she's relatively well-known, super well-known actually, and she gets basically nothing out of Spotify. On top of that, of course, there are general concerns about workforce being displaced by artificial intelligence, and thinking about the potentials, economic potentials of exporting some of our cultural assets to other countries, not just Lusophone countries, but then potentials for conventional streaming platforms like Netflix. So during the pandemic, for instance, when that was the setting, there was no direct support by the government. What we had was just that sort of investment. So I guess that plays a different picture. But also on the other hand, the issue of regulating platforms, what you see, and maybe that's one of the things that's being discussed outside of Brazil more, is how the Supreme Court has taken a very active role in regulating platforms. And even this week, they're about to finalize a reframing out of long-standing provision that was basically a safe harbor non-liability for platforms that is about to be reshaped. And some people in the international literature are even calling it kind of a Brazil model in the making. But part of it and where it fits into remuneration is that very explicitly the government is saying to counter misinformation is not just about digital literacy, but also about having enough instruments to support journalism, quality journalism, alternative journalism, Black-owned journalism, Indigenous peoples owned journalism, women-owned journalism, and because of a fading business model, that also means that potentially new support in the form potentially of remuneration can be part of this agenda. This is just one example. There, of course, dubbing in Brazil is a really huge cultural industry in economic sense, but you see this kind of campaign that is trying to not only talk about the loss of a whole profession, but also how this fits into notions of being Brazilian. What does it mean? What does it mean to speak Brazilian Portuguese? What does it mean to export it all and being translated into an AI? And Netflix actually did this in a few occasions. It's not, therefore, just a workforce displacement issue, but also that broader cultural repercussion that needs to be taken into account. I just wanted to add as well a couple of other issues that I think are important for us to understand it more broadly. I think the core in Brazil would be there's more reasons to be concerned about misappropriation, particularly when we're talking about minorities, than de facto issues with LNEs not existing, and I'm referring, of course, to Alan's very well-known argument of how courts in Brazil have historically been trying to compensate a bad legislation that does not really have LNEs, but that de facto end up authorizing utilizations, for instance, for both research and educational purposes, in a way that in the policy realm, there's also more reasons to be concerned about what's going on. Sorry, I put open source, but it's actually open access, of course, with the provisions related to big funders that are licensing some of our preservation and museums and archives policies that often just have that blunt open access provisions that are not really aligned with the way you need to negotiate and ponder things with indigenous peoples. And the picture here is showing the launch of the University of São Paulo's new Center of Documentation of Indigenous Languages and Cultures that took place a couple of weeks ago. It's a very exciting, huge project. And one of the main issues there is precisely how do you do preservation and archival resources with direct participation of indigenous peoples. And one of the main issues is you can't start with an access provision. It might end with that, but then you need to calibrate issues related to traditional knowledge. So when we bring that kind of concrete issue and we translate into like broad WIPO kind of resources, that also means that Latin America in general has potentially more reasons, at least for now, to be focusing on the traditional knowledge part of things. So from all of what I said, I guess one of the two main takeaways for now is that there's a renewed importance of public speeches around remuneration rights, and also how regulation of AI is part of both the direct regulation of huge platforms, but also the issue of the creative industries in Brazil. And one particular point there is that industry representatives always insist, just like everywhere else, on the innovation versus regulation trade-off, arguing that if we regulate too much, then there won't be AI innovation in Brazil. And I think that's a good point to just mention a little bit the status of what's going on in Brazil. We often refer to what's taking place at the new AI draft bill, but I think it's important as well to note that there are other processes at the National Congress right now, including 2 streaming draft bills. And again, their focus, it's kind of a convoluted language for now, to be honest, but it relates to more clearly delineating anti-competitive practices that could support competition authority scrutiny, but also a broader long-standing agenda of ensuring national consent or quota mechanisms for streaming as well. Just like in other countries, like the famous example of France, you have national quota mechanisms for audiovisual, but you don't have that for streaming. So that's one of the core policy discussions. And then that's where we get to the current AI draft bill. And one of the things I just wanted to highlight, and the reason why I started with that broader framing, is that so the current text, after tons of different forms of submissions, continues to include a research exception for non-commercial uses, but does include something that would be the inverse of the European opt-out mechanism. I think that's important to stress. There's a lot of people arguing that so far there's no clear way of technically implementing what's being proposed. What the government has been responding is that the fact that it's not so clear as of now how to technically implement issues like transparency reporting or opt-out mechanisms or any other forms or variations thereof is not sufficient reason not to include such mechanisms in the law in the first place. Something I would agree. But I think that what's important there is that there's a specific delineation of remuneration rights for users related to mining, training, and development of AI systems. But 2 elements that are often overlooked, and I think they're useful for our discussion here, is the fact that you have reciprocity between jurisdictions as a rule. So Brazilian copyright law, because of TRIPS, of course, does not discriminate between nationals and foreigners, but they're trying to implement there something a little bit distinct. It's something for open discussion, of course, but then the issue of if you don't have equivalent remuneration protection for Brazilian rights holders in the other jurisdiction, then that won't be applicable to you in Brazil. I think that's important also in terms of international negotiations and discussions. But then also the second point is that the quantum of remuneration, the exact amount, should be dependent on, that's important, the size of the institution or company that is training the AI and its competitive effects. This is, of course, something that is not so clear, but then I think it's important to understand what's the background of this whole discussion. So where do we stand? I think that although all of those things overlap, it's important to distill and differentiate issues of having the consent, authorization, and misappropriation. I think that's core for all the stakeholders in Brazil, perhaps even more so than in other jurisdictions, and that's the case of Latin America as well. I think it's also important to see this difference between the cases where remuneration has been used strategically, so to say, as perhaps the only last possibility for a fading existing business model. And that's obviously the case of journalism. That's the way journalism organizations have been advocating for this bill in Brazil. And people would respond by saying, you need to find something else. And then they're say it again and be like, if you don't give us any form of remuneration, we'll simply no longer exist in a few years. But what ties everything is just general concern about corporate power by foreign players in particular. This is not to say, of course, that there are not huge Brazilian conglomerates that are part of this discussion, but I guess it's this foreign domestic division has been important as well for the way we've been framing these discussions. And that's where I get to the point that AI regulation and remuneration are, of course, part of all of that. But I think we cannot really totally dissociate issues of the research questions with everything else. So getting to the last part of the presentation. So how does this all relate to what the group of Latin American and Caribbean countries have been bringing to WIPO? I think one point is that WIPO is not the only arena where this has been brought by Latin American countries in Brazil in particular. The G20 has been an important arena as well, the BRICS, the Organization of Ibero-American States, and some less well-known organizations. This is where not necessarily a treaty is the end goal, but just trying to see if common experiences and some policy coordination can be useful. I think that's important. I think implicitly the other point is that we need to understand that the regulation efforts are always harder in Latin America than they are in regions like Europe, where also socioeconomic problems are, of course, much larger. And of course, the case we always refer to is how Uruguay amended its copyright law to include fair and equitable remuneration, and right after Spotify threatened to leave the country. Of course, Brazil is not Uruguay in terms of the economic size and of the population and the market, but that kind of a threat, similar to what we saw, for instance, with compulsory licensing. Germany issued a compulsory license with its federal court. No consequence whatsoever from that economic threatening point of view. That obviously is not the case in any Latin American country, but also with respect to how consolidated and strong are the CMOs in the continent. So all of this, of course, brings the North-South issue as a very prominent feature of this discussion, because we just referred to how Europe has important reference to fair remuneration in their own domestic regional legislations. Meanwhile, they refrain from accepting the advancement of such discussions at WIPO. So I think this, and I believe this will make sense, getting straight to the two last slides that will try to compile the core message of what I want to say, is that so when GRULAC decided to update a proposal that was originally tabled in 2015, pursuant as well to two different market studies made by the WIPO Secretariat, so there was a new player, AI, new issue, but I guess more generally, there's also the sense of trying to get something that would be focused on Latin American preoccupations, both in terms of where the economies can be much stronger, cultural industries, but also where they're suffering the most. So I guess it's a way of understanding that, at least for now, it's really more about trying to consolidate the discussions, generally speaking, rather than one single topic. Usually European Union has been saying, oh, this is going, everywhere, all over the place. We don't really know where this is going to take us. But I guess that's, this political economy of what's taking place in the continent helps us understand that. So I guess that this can be helpful for us to understand that when remuneration is referred to at WIPO at this point, there's the issue of the debate on the promotion of cultural industries. That's one thing. But then there's also these two other aspects, broader corporate power regulation and AI regulation. It's very clear that they often overlap. I think it's been useful for us to try to differentiate those things, but even more importantly, dismissing as a non-issue or as unimportant as sometimes that has been taking place in the past few years can be seen as quite patronizing for Latin American countries. So now the last slide, how do you place remuneration into a potential LNE instrument? I just have two main messages. So it cannot be an afterthought, and I'm honestly not really sure whether this should be included at all. If we are to simply have a language referring to nothing in this instrument will prevent remuneration, or, remuneration should not prevent the enjoyment of LNEs, I think you get into a political economy problem at WIPO. So I think what's the last differentiation I wanted to make for this presentation is I think there's good reasons to separate how remuneration broadcasting LNEs are bundled together at WIPO because of the agenda and the way historically these items have come through. And another thing is trying to cross-reference them in a single instrument. At least for now, I'm not so sure about what I'm saying. It seems to me that there's not really such a place in the cross-referencing part, although there's obviously a lot of space in dealing with these three together from a WIPO agenda point of view. Thank you very much. Looking forward to the discussion.